Canon 1908. A beneficiary is a named or unnamed party at the time of the formation of the trust who benefits or receives an advantage in trust. A beneficiary, by definition, is an interested party in a trust or estate. A named beneficiary is an agent, with the trustee being the principal, and may be commissioned or non-commissioned, and 2. An unnamed beneficiary is a creditor, with the trustee acting as debtor, to whom the trustee owes basic duties arising by law, agreement, or claim. Canon 1909. All valid trusts, by their formation, are classified as either instructed trusts or facilitated trusts and must possess the following 10 essential characters of trust, being rights, trustor, trustee, reason, intention, benefit, condition, oath and vow, execution and proof. Rights means there must be something that may be clearly defined in terms of rights or property to convey in the first instance, and 2. Trustor means there must be a valid trustor or surrogate trustor, as in the case of a facilitated trust, possessing the necessary authority to transfer any rights or property to another, and 3. Trustee means there must be a suitably competent, capable, and willing person prepared to make a valid oath and vow to accept custody of the rights or property from the trustor or surrogate trustor, and 4. Reason means there must exist at least one clear purpose or valid reason for the trustor to convey and transfer the rights or property to the trustee, and v. Intention means the trustor or surrogate trustor must demonstrate via some act their intention to convey and transfer the rights or property to the trustee, and 6. Benefit means there exists a clear benefit to be offered to another as one or more named or unnamed beneficiaries, and 7. Condition means at least one or more terms and conditions exist as to the obligations of the trustee to manage such rights or property and also to any beneficiaries accepting one or more benefits, and 8. Oath and vow means the person agreeing to be trustee made a valid oath and vow to accept the rights or property under one or more conditions, and 9. Execution means the trustor and trustee executed the formal transfer and conveyance of such rights or property after the valid oath and vow was given, and X. Proof means some proof in the form of written instruments or testimony under valid oath and vow exists as a memorial of the event and execution of the agreement. Canon 1910. A trust that is deficient in possessing one or more of the 10 essential characters of trust cannot be regarded as a valid trust. There can never be less than 2 separate and distinct persons involved in the valid creation of a trust, even if a trustor is a surrogate, and 2. A person cannot be both the trustee/administrator and beneficiary at the same time, nor can the same person be both executor and trustee at the same time, and 3. No valid trust may exist where the legal title and beneficial interest are both vested in the same person, and 4. The rights administered by the trustee cannot exceed the original rights conveyed by the trustor, and v. It is the oath and vow of the trustee that essentially forms the fundamental character of the trust. Therefore, in the absence of any record of a valid oath or vow, there is no trust, and 6. As a trustee is bound by fiduciary capacity to act in good trust, bona fide, good character, and good conscience, any trust formed under bad faith, false, deceptive or misleading behavior automatically renders such a trust null and void from the beginning, and 7. As the presence of at least one trustee is fundamental to the existence of a trust, the absence of a trustee from such office, without a duly appointed surrogate, therefore collapses the trust, and 8. A trustee that fundamentally breaches one or more conditions of the trust, even if the trust was formed under proper fiduciary capacity, automatically dissolves his/her office and oath and vow, thus dissolving the trust, if only one trustee exists. Canon 1911. All valid trusts may be further categorized according to the essential status and authority of the trust or, being divine, living, or deceased. I. The highest form of trust is a divine trust also involving the highest form of rights of ownership. A divine trust is purely spiritual and divinely supernatural, formed in accord with the sacred covenant Pactum De Singularus Caelum by the divine creator, whereby the form of divine spirit, energy, and rights are conveyed. Therefore, a divine trust is the only possible type of trust that can hold actual form, rather than just the rights of use of form, property, and 2. A living trust, also called an inter vivos trust, is the second highest form of rights of ownership. A living trust typically exists for the duration of the lifetime of the person, s, or juridic person, s, who are the beneficiaries. There are only four valid forms of living trusts: true, superior, temporary, and inferior, and 3. A deceased trust, also known as a testamentary trust, also known as a deceased estate. And simply estate is the lowest form of trust and the lowest form of rights of ownership of any possible form of trust. A deceased trust is when property is conveyed into a testamentary trust upon the death of the testator. Inferior Roman law has a hybrid deceased trust called a cestui que vi trust that uses false, deceptive, misleading, absurd, immoral, repugnant, and illogical presumptions to create deceased estates for the living on the presumption they are dead at law, or lost or abandoned at sea, or an idiot or lunatic. Canon 1912. In respect of the four types of living trusts being true, superior, temporary, and inferior. I. A true trust is the highest form of living trust. A true trust is formed by a true person in accord with the sacred covenant Pactum De Singularis Caelum when it is validly registered into the Great Register and Public Record of a Hokkaidan society on the condition of 1. The pre-existence of a divine trust where the true person is the named beneficiary, and 2. The lawful conveyance from the divine trust into the true trust of certain divine rights of use known as divinity, being the highest possible form of any kind of property. A true trust may be for a single man or woman called a true person trust, a true location trust containing divine right of possession of promised land, or an aggregate trust such as a universal true trust, global true trust, or civil true trust, and 2. A superior trust is the second highest form of living trust. A superior trust is formed in accordance with the covenant Pactum De Singularis Caelum and the associated constitutional charters of valid Hokkaidan societies when it is validly registered into the Great Register and Public Record of a Hokkaidan society on the condition of 1. The pre-existence of a true trust, where the superior person is the named beneficiary, and 2. The lawful conveyance from the true trust into the superior trust of certain true rights of use known as absolute realty, being the highest temporal form of any kind of property. A true trust may be for a single man or woman, called a superior person trust, or an aggregate trust such as a global, superior, trust, civil, superior, trust, mercantile, superior, trust, union, superior, trust, clan trust, official trust, or location trust, and 3. A temporary trust is the third highest form of living trust involving the temporary conveyance of property from one superior trust to another. Excluding negotiable instruments, a temporary trust is not permitted to exist beyond 7 years, and 4. An inferior trust, also known as an inferior Roman trust, or simply Roman trust, is the lowest form of living trust possessing the lowest possible form of rights of ownership. An inferior trust can never be considered superior to a superior trust or divine trust. An inferior trust is any living trust or implied trust or express trust formed by inferior Roman law, claims, and statutes. Canon 1913. In respect of the authority and power of the classes and types of trusts. A divine trust ceases upon the will of the divine creator of all existence in accord with the sacred covenant Pactum De Singularis Caelum and no other. A divine trust cannot be salvaged, seized, captured, arrested, alienated, resigned, abjured, transferred, conveyed, donated, assigned or surrendered, and 2. A true trust ceases upon the physical death of the body, or body politic that is associated with it. A true trust is not dependent upon the good character or intentions or actions of the trustee or trustees. Furthermore, a true trust cannot be salvaged, seized, captured, arrested, alienated, resigned, abjured, transferred, conveyed, donated, assigned, or surrendered, and 3. A superior trust ceases upon its dissolution, satisfaction, termination, cessation or annulment, with the residential or property of the trust being returned or again distributed or disposed. Accordingly upon the publication and patenting of an official gazette notice within the Hokkaido Gazette, as evidence to the fact, and 4. A temporary trust ceases upon its dissolution, satisfaction, termination, cessation or annulment, with the residential or property of the trust being returned or again distributed or disposed. Accordingly upon proper notice, in accord with the sacred covenant Pactum De Singularis Caelum or associated covenants, canons, and rules of Hokkaido, and v. An inferior trust ceases upon its dissolution, satisfaction, termination, cessation or annulment, with the residential or property of the trust being returned or again distributed or disposed. Accordingly upon either the publication and patenting of an official gazette notice within the Hokkaido Gazette, as evidence to the fact, or by such rules of inferior law, providing such rules do not contradict the sacred covenant Pactum De Singularis Caelum or associated covenants, canons and rules of Hokkaido. Canon 1914. Examples of inferior trusts, also known as Roman trusts include, but are not limited to: I. Accumulation trust is a form of inferior, Roman, trust whereby the trustees are directed to accumulate income and gains from sales of trust assets for ultimate disposition when the trust is terminated, and 2. Active trust is a form of inferior, Roman, trust that imposes upon the trustee the duty of taking active measures in the execution of the trust, as, where property is conveyed to trustees, with directions to sell and distribute the proceeds among creditors of the grantor, as distinguished from a passive or dry trust. In a passive trust, the legal and equitable titles are merged in relation to the beneficiaries and beneficial use is converted into legal ownership, while in an active trust, the title remains with the trustee for the purpose of the trust, and 3. Alimony trust is a form of inferior, Roman, trust device used to secure the obligation of a husband to pay support or alimony for wife, or a transfer by the husband to the trustee of property with the wife as beneficiary to then be supported after divorce or separation, and 4. Annuity trust is a form of inferior, Roman, trust whereby the trustee is required to pay a sum certain annually to one or more individual beneficiaries for their respective lives or for a term of years, and thereafter either transfer the remainder to or for the use of a qualified charity, or retain the remainder for such a use. The sum certain must not be less than 5% of the initial fair market value of the property transferred to the trust by the donor, and v. Bond trust is a form of inferior, Roman, trust whereby the res property of the trust consists in bonds that yield interest income, and 6. Sestuique trust is a form of inferior, Roman, trust whereby a trust is established on one or more presumptions including, but not limited to, one or more persons presumed wards, infants, idiots, lost or abandoned at sea and therefore assumed/presumed dead after 7 years, and thus, in the absence of a valid beneficiary, one or more other persons may claim the benefit of the trust, and 7. Charitable remainder trust is a form of inferior, Roman, trust that consists of assets that are paid over to the trust after the expiration of a life estate or intermediate estates and designated for charitable purposes, and 8. Charitable trust is a form of inferior, Roman, trust designed for the benefit of a class or the public generally. They are essentially different from private trusts in that the beneficiaries are uncertain. In general, such must be created for charitable, educational, religious or scientific purposes, and 9. Clifford trust is a form of inferior, Roman, trust as a tax planning device, whereby a transfer of income-producing property is made to a trust whereby provides that the income is either to be paid or accumulated for the benefit of a beneficiary other than the grantor for a period of more than 10 years, and at that time the trust is to terminate and the property reverts back to the grantor, and X. Community trust is a form of inferior, Roman, trust whereby an agency organized for the permanent administration of funds is placed in trust for public health, educational or charitable purposes, and 11. Complex trust is a form of inferior, Roman, trust being any inferior trust other than a simple inferior trust, and one whereby the trustees have discretion as to whether to distribute and discretion as to amounts distributed, and 12. Constructive trust is a form of inferior, Roman, trust raised by construction of law, or arising by operation of law, as distinguished from an express trust. Wherever the circumstances of a transaction are such that the person who takes the legal estate and property cannot also enjoy the beneficial interest without necessarily violating some established principle of equity, the court will raise a constructive trust, and fasten it upon the conscience of the legal owner, so as to convert him into a trustee for the parties who in equity are entitled to the beneficial enjoyment. Such trusts are also known as trusts ex maleficio or ex delicto or involuntary. Trusts in their forms and varieties are practically without limit, being raised by courts of equity whenever it becomes necessary to prevent a failure of justice, and 13. Contingent trust is a form of inferior, Roman, trust as an express trust depending for its operation upon a future event, and 14. Directory trust is a form of inferior, Roman, trust that is not completely and finally settled by the trust instrument creating it, but only defined in its general purpose and to be carried into detail according to later specific directions, and 15. Discretionary trust is a trust whereby trustees have discretion as to types of investment, and also as to whether and when distributions may be made to beneficiaries, and 16. Dry trust is a form of inferior, Roman, trust that merely vests the legal title in the trustee, and does not require the performance of any active duty on his part to carry out the trust, and 17. Educational trust is a form of inferior, Roman, trust for the founding, endowing and supporting of schools for the advancement of all useful branches of learning, that are not strictly private, and 18. Equipment trust is a form of inferior, Roman, trust as a financing method commonly used by railroads whereby the equipment's title is transferred to trustees as security for the financing, and 19. Estate trust is a form of inferior, Roman, trust of an estate, for all or part of the income to be accumulated during the surviving spouse's life and added to corpus res, with the accumulated income and corpus being paid to the estate of the surviving spouse at death. This type of trust is commonly used to qualify property for the marital deduction, and XX, executed trust is a form of inferior, Roman, trust whereby the scheme has from the outset been completely declared. A trust whereby the estates and interest in the subject matter of the trust are completely limited and defined by the instrument creating the trust, and require no further instruments to complete them, and XXI, executory trust is a form of inferior, Roman, trust that requires the execution of some further instrument, or the doing of some further act on the part of the creator of the trust or of the trustee, toward its complete creation or full effect, and XXII, express active trust is a form of inferior, Roman, trust that confers upon the executor certain authority to generally manage property of the estate and pay over net income to devisees or legatees. Such authority creates an express active trust, and XXIII, express private passive trust is a form of inferior, Roman, trust that exists where land is conveyed to or held by one person in trust for another, without any power being expressly or impliedly given to the trustee to take actual possession of land or exercise acts of ownership over it, except by beneficiary's direction, and XXIV, express trust is a form of inferior, Roman, trust created or declared in express terms, and usually in writing, as distinguished from one inferred by the law from the conduct or dealings of the parties. A trust directly created for specific purposes in contrast to a constructive or resulting trust that arises by implication of law or the demands of equity. Such trusts are created by the direct and positive acts of the parties, by some writing, or deed, or will, or by words expressly or impliedly evincing an intention to create a trust, and XXV, fixed trust is a form of inferior, Roman, trust being a form of non-discretionary trust, whereby the trustee may not exercise his own judgment, and XXVI, foreign trust or foreign situs trust is a form of inferior, Roman, trust that owes its existence to foreign law. It is treated for tax purposes as a non-resident alien individual, and XXVII, fraud trust or simply fraud is a form of inferior, Roman, trust, also known as an involuntary trust and usually a secret trust, being an implied trust and constructive trust, claimed under the control of a court of equity, as a surrogate court of chancery, formed on some claimed breach of trust, or some presumed gross maladministration or false, misleading or other criminal acts, causing a trust within the Roman system to cease. Fraud trusts are usually created at the same time of creation of case numbers, and bonds, and before any proof of default or delinquency on either the beneficiary or trustee of the claimed collapsed trust. The Roman court then uses hearings, trials, confessions, and unchallenged evidence to prove liability, and therefore penalty and compensation, and XXVIII, grantor trust is a form of inferior, Roman, trust whereby the grantor transfers or conveys property in trust for his own benefit alone or for himself and another, and XXIX, honorary trust is a form of inferior, Roman, trust for specific non-charitable purposes, where there is no definite ascertainable beneficiary and hence unenforceable in the absence of statute, and XXX, illusory trust is a form of inferior, Roman, trust being a trust arrangement that takes the form of a trust, but because of powers retained in the settlor, has no real substance and in reality is not a completed trust, and XXXI, implied trust is a form of inferior, Roman, trust being a trust raised or created by implication of law. An implied trust is a trust implied or presumed from circumstances. Constructive and resulting trusts are implied trusts because they arise by implication of law or by demands of equity, and XXXII, indestructible trust is a form of inferior, Roman, trust being a trust that it is claimed may not be terminated or revoked, and XXXII, insurance trust is a form of inferior, Roman, trust being a trust whereby the res property of trust, of the trust consists of insurance policies or their proceeds, and XXXIV, inter vivos trust is a form of inferior, Roman, trust being a trust created by an instrument that becomes operative during the settler's lifetime as contrasted with a testamentary trust that takes effect on the death of the settler, and XXXV, involuntary trust is a form of inferior, Roman, trust, usually a secret trust, whereby a trust is raised by the doctrines of equity, chancery court/division, within a competent forum, holding equity powers, for the purpose of conducting a Roman court proceeding having commercial value, i.e. creation of bonds, when there is no intention of the parties to create a trust relation. This class of trusts may usually be referred to as a fraud trust or simply fraud, either actual or implied, as an essential presumption of their creation. In other words, where a Roman court presumes a party is guilty of a breach of trust, or dereliction of duty or delinquency, as actual or implied fraud is the basis of forming an involuntary trust before any default is proven, and XXXVI, irrevocable trust is a form of inferior, Roman, trust. Such a trust may not be revoked after its creation, as in the case of a deposit of money by one in the name of another as trustee, for the benefit of a third person, beneficiary, and XXXVII, limited trust is a form of inferior, Roman, trust created for a limited period of time in contrast to a perpetual trust, and XXXVIII, liquidation trust is a form of inferior, Roman, trust created for purpose of terminating a business or other undertaking and for distributing the res, and XXXIX, living trust is a form of inferior, Roman, trust. An inter vivos trust created and operative during the lifetime of the settler and commonly for benefit or support of another person, and XL, mixed trust is a form of inferior, Roman, trust. Trusts established to benefit both private individuals and charities, and SLE, naked trust is a form of inferior, Roman, trust, also known as a dry or passive trust, being one that requires no action on the part of the trustee, beyond turning over money or property to the Sestuike trust, and SLE, nominee trust is a form of inferior, Roman, trust being an arrangement for holding title to real property whereby one or more persons or corporations, pursuant to a written declaration of trust, declare that they will hold any property that they acquire as trustees for the benefit of one or more undisclosed beneficiaries, and SLIEN, non-discretionary trust is a form of inferior, Roman, trust being a fixed trust whereby the trustees may exercise no judgment or discretion at least as to distributions, and SLIV, passive trust is a form of inferior, Roman, trust whereby the trustee has no active duty to perform. Passive trust, that an equity court may terminate before it ends by its terms, is one whereby the trustee does not have responsibilities or discretionary duties to perform, and XLV, perpetual trust is a form of inferior, Roman, trust whereby a trust is to continue as long as the need for it continues, as for the lifetime of a beneficiary or the term of a particular charity, and SLV, pour-over trust is a form of inferior, Roman, trust whereby a testator leaves the residue of his estate to a trustee of a living trust via a provision in a will for purpose of that pour-over trust, and SLEI, power of appointment trust is a form of inferior, Roman, trust being a type of trust used to qualify property for the marital deduction. Property is left in trust for a surviving spouse. The trustee is required to distribute income to the spouse for life, and the spouse is given an unqualified power to appoint the property to herself or to her estate, and SLEIATH, precatory trust is a form of inferior, Roman, trust where words employed in a will or other Instrument do not amount to a positive command or to a distinct testamentary disposition, but are terms of entreaty, request, recommendation, or expectation. They are termed precatory words, and from such words the law will raise a trust, called a precatory trust, and slicks. Private trust is a form of inferior, Roman, trust. One established or created for the benefit of a certain designated individual or individuals, or a known person or class of persons, clearly identified or capable of identification by the terms of the instrument creating the trust, as distinguished from trusts for public institutions or charitable uses. Public trust is a form of inferior, Roman, trust. One constituted for the benefit either of the public at large or of some considerable portion of it answering a particular description. Public trusts and charitable trusts may be considered in general as synonymous expressions, and L. Resulting trust is a form of inferior, Roman, trust arising by implication of law, or by the operation and construction of equity, and is established as consonant to the presumed intention of the parties as gathered from the nature of the transaction. It arises where the legal estate in property is disposed of, conveyed, or transferred, but the intent appears or is inferred from the terms of the disposition, or from the accompanying facts and circumstances, that the beneficial interest is not to go or be enjoyed with the legal title. Revocable trust is a form of inferior, Roman, trust whereby the trustor reserves the right to revoke, and secret trust is a form of inferior, Roman, trust where a trustor gives property to a person on a verbal or written promise by the legatee or devisee that he will hold it in trust for another, but will not make the existence of the trust known to the beneficiary until some event or issue. Involuntary trusts are frequently formed as part of Roman court proceedings, and shifting trust is a form of inferior, Roman, trust being an express trust that is so settled that it may operate in favor of beneficiaries additional to, or substituted for, those first named, upon specified contingencies, and short-term trust is a form of inferior, Roman, trust being a trust that by its terms is to be administered for a short period of time and then terminated, and simple trust is a form of inferior, Roman, trust whereby property is simply vested in one person for the use of another, and the nature of the trust, not being qualified by the settlor, is left to the construction of law. A simple trust is a trust that provides that all of its income is required to be distributed currently, even if it is not in fact distributed, does not provide that any amounts are to be paid, permanently set aside, or used for charitable purposes, and does not distribute any amount other than current income. Simple trusts are those that are not complex trusts. Such trusts may not have a charitable beneficiary, accumulate income, nor distribute corpus, res, and lvi. Special trust is a form of inferior, Roman, trust whereby a trustee is interposed for the execution of some purpose particularly pointed out, and is not, as in case of a simple trust, a mere passive depositary of the estate, but is required to exert himself actively in the execution of the settlor's intention, as where a conveyance is made to trustees upon trust to reconvey, or to sell for the payment of debts, and testamentary trust is a form of inferior, Roman, trust being a trust created within a will and executed with the formalities required of a will in contrast to an inter vivos trust. A trust that does not take effect until the death of the testator, and Totten trust is a form of inferior, Roman, trust being a trust created by the deposit by one person of his own money in his own name as a trustee for another and as a tentative trust. Revocable at will until the depositor dies or completes the gift in his lifetime by some unequivocal act or declaration such as delivery of the passbook or notice to the beneficiary, and if the Depositor dies before the beneficiary without revocation or some decisive act or declaration of disaffirmance. The presumption arises that an absolute trust was created as to the balance on hand at the death of the depositor. Canon 1915. The office of trustee ceases I. At the dissolution or satisfaction or termination or cessation or annulment of the trust, or 2. Upon the death of the trustee, and 3. Abandonment, when a trustee is away from the domicile of the trust for more than 2 years, without word or adequate response, and 4. Resignation, when a trustee resigns from the duties of such office, and v. Refusal, when a trustee refuses to act in the manner and characteristics required of such office, and 6. Contestation, when the competency or legitimacy of a trustee is challenged and upheld by a competent forum of law. Canon 1916. A superior trust, temporary trust, or inferior trust ceases upon its dissolution, satisfaction, termination, cessation, or annulment, with the residential or property of the trust being returned or again distributed or disposed accordingly. I. Satisfaction of trust means a trust has fulfilled all its obligations and is therefore finished and ceases upon the return, distribution, or disposal of the property, and 2. Termination of trust means a trust that ceases due to a condition of its operation, usually documented within the trust instrument, requiring the trust to end upon some fundamental breach or failure to perform, and 3. Dissolution of trust means a trust that dissolves according to the operation of law, usually upon some declaration that the trust is unable to fulfill its obligations, as in bankruptcy, or some other obstruction or major defect as determined within a competent forum of law, and 4. Annulment of trust means a trust that ceases to be, upon the strike or removal of such record of its existence, or condemnation as unfit or contrary to the principles of fiduciary capacity, and any property returned to the trustor as if the trust never existed, and v. Cessation of trust means a trust ceases to be in effect, due to some catastrophic event or act, such as a fundamental breach of trust that renders the continuation of such a trust impossible, and to the effect as if the trust had been annulled. Canon 1917. A trustor may cease, terminate, dissolve, and annul a trust in action against the trustee, s. upon evidence of one or more breaches of trust. I. When a trust is formed by the trustor as grantor, then by renunciation of any such grant, a trustor may lawfully regain repossession and restitution, and 2. When a trust is formed by the trustor as donor, then by reclamation of such original rights, a trustor may lawfully regain recovery and restoration, and 3. When a trust is formed by the trustor as assignor, then by rescission of any sign, signature, or seal of execution, a trustor may lawfully regain and return and reversion, and 4. When a trust is formed by the trustor as delegator, then by revocation of any instrument of appointment or powers, a trustor may lawfully regain remand and revestiture. Canon 1918. A party becomes a beneficiary upon use, or claim, or acceptance, and therefore obligated to perform the duties associated with the benefits in trust. However, a party once becoming a beneficiary may then cease, terminate, or dissolve any interest or obligation by one of the following actions. I. If a beneficiary by acceptance, then upon acknowledgement of proof of purchase, i.e. bill of sale, or by deed signed by another party then proving the property or interest is no longer in their possession, or by surrender of the property or interest by deed, and 2. If a beneficiary by claim, then by deed of disclaim or withdrawal of any interest, and 3. If a beneficiary by use, when no formal acceptance or claim acknowledged, then by both surrender and disclaim as a cessation of any past, present and future use. Canon 1919. A person proven to have acted in fraud or breach of their fiduciary duties as a trustor or a trustee automatically ceases to hold the position from the time of the fraud or breach. Any liability associated with a fraud or breach of duty of a former trustor or trustee is automatically personally assumed by the disgraced former trustor or trustee. Canon 1920. Any claim that an inferior Roman trust possesses superior standing and rights of ownership compared to a superior trust, or true trust is an absurdity against divine law, natural law and positive law, and therefore is null and void from the beginning, including any associated covenants, deeds and agreements concerning property rights and lesser trusts. Article 85, Divine Trust. Canon 1921. A divine trust is a purely spiritual trust validly registered into the Great Register and public record of one heaven, containing actual spiritual form as well as divine property, administered by the treasury of one heaven as trustees in accordance with the sacred covenant Pactum De Singularis Caelum as sacred deed for the benefice of a divine person. Canon 1922. In accordance with the most sacred covenant Pactum De Singularis Caelum, a divine trust has been created, is created, and will be created for every single man, woman and higher order spirit that has ever existed, or is living at this moment, or will live and exist in the future. Canon 1923. By definition of divine law and natural law, the divine creator is the one, true and only owner of all objects and concept. This is because, except for the divine creator, objects and concepts cannot own one another, only themselves. This also means that a fiction, such as a trust, cannot own or hold any object or concept, only another fiction. Canon 1924. A divine trust is the highest possible form of trust and unique as the only possible type of trust that can hold actual form, rather than the rights of use of form being property. Canon 1925. In accordance with these canons, a divine trust can never be terminated. Canon 1926. A divine trust is formed when a divine immortal spirit, being part of the divine, agrees with the intention of the collective divine known as unique collective awareness to be recognized as a unique member of the divine in accordance with the sacred covenant Pactum De Singularis Caelum. Into the divine trust is then placed one unit of pure awareness representing one unique divine immortal spirit and mind, one unit of awareness representing the unique experience of form and motion, energy, of creation and connection to form, and one unit representing all unique awareness of experience of unique form and motion as the divine form. Canon 1927. In accordance with these canons and the sacred covenant Pactum De Singularis Caelum, a divine immortal spirit is defined as any unique collective awareness associated with the formation and existence of a specific form of matter within a level of space within the universe. Therefore the universe as a whole is a divine immortal spirit, the Milky Way galaxy is a divine immortal spirit as well as physical aggregate of matter as is the divine immortal spirit of a member of the Homo sapien species native to the planet Earth. Canon 1928. The divine form conveyed into a valid divine trust for a divine immortal spirit is known as the divine corpus, or divine living body representing a valid legal personality known as the divine person. Canon 1929. No form contained within a valid divine trust may be conveyed, nor any transactions or effects undertaken on behalf of the trust unless it is in accord with these canons and the sacred covenant Pactum De Singularis Caelum. Canon 1930. Any claimed ownership, conveyance, lien, or other fictional device over any form within a divine trust that are not in accordance with these canons is a fraud and gross injury to the divine creator and therefore automatically null and void from the beginning. Canon 1931. A divine immortal spirit may only be associated with one valid divine trust and therefore one valid divine person. Canon 1932. A divine person created for an organic higher order life form may only be associated with one Flesh vessel as trustee of a valid true trust and therefore 1 valid true person whilst the flesh lives. Canon 1933. In accordance with these canons, every child or higher order spirit that is born from now until the end of time possesses a divine personality through the creation of their divine trust before any other legal entity or claim. Canon 1934. When a particular divine person of an organic higher order life form no longer has any valid association to a true trust in a living flesh vessel, then an association is permitted whereby 100 divine persons in similar condition come together as an aggregate to form a supreme divine trust. Canon 1935. In accordance with these canons and the sacred covenant Pactum de Singularis Caelum, all men, women and higher order life, living and deceased are members of one heaven, therefore possessing a unique divine trust and divine personality as demonstrated and proven by the existence of a unique membership number for them. Canon 1936. As all men, women, and higher order spirits, living and deceased are automatically members of one heaven in accordance with the sacred covenant Pactum de Singularis Caelum, it is not necessary to give further notice to any man, woman, or higher spirit of the existence of their divine trust beyond the publication of these canons and the sacred covenant to this fact. Canon 1937. The divine creator is the owner of all divine trusts. Therefore, no individual spirit, person, entity or aggregate has the lawful right to demand the termination of a divine trust in a divine person. Article 86, True Trust. Canon 1938. A true trust is a form of living trust containing divine property known as divine rights of use, or divinity that is validly registered into the Great Register and Public Record of a global Okadian society. A true trust may be for a single man or woman called a true person trust, a true location trust containing divine right of possession of promised land, or an aggregate trust such as a universal true trust, global true trust or civil true trust. Canon 1939. By definition, divinity or divine rights of use cannot exist without the existence of a divine trust. Therefore, no valid true trust may exist unless it is connected and created from a valid divine trust. Canon 1940. A true trust is the second highest possible form of any type of trust holding the highest possible form of any kind of property being divine rights of use known as divinity. Canon 1941. A true trust may only be associated with one valid divine trust and therefore one valid divine person. A divine person is always the owner and grantor of a valid true trust. Canon 1942. A true person trust is formed when a divine person grants certain divine rights of use, known as divinity, into the true person trust, creating the trust corpus of the true trust, also known as the true body corporate, also known as the true person, having legal personality. The mind and brain of the flesh vessel is always the general executor and guardian of the flesh. The flesh vessel, also known as the living flesh, also known as the living body of the organic higher order life form, is always the trustee with the true person as beneficiary. Canon 1943. When the executor and trustee dies, the true person also dies. As a living, inter vivos, trust, a true trust lawfully terminates upon the death of the person or juridic person listed as beneficiary. Canon 1944. Any property rights granted from a true trust may only be conveyed to a superior trust of the same name and no other. Canon 1945. In accordance with these canons and the sacred covenant Pactum de Singularis Caelum, each and every living man and woman have been duly appointed executor in mind and trustee in flesh of a unique true trust through the conveyance of divine rights by divine personality. Article 87, Superior Trust. Canon 1946. A superior trust is a form of living trust validly registered into the Great Register and Public Record. of a global, or national, or local Locadian society or entity containing real property, also known as realty, being the highest form of rights of use of object and concepts administered in accordance with these canons and its sacred covenant as deed for the benefit of a superior person. A superior trust is the third highest form of trust. Canon 1947. By definition, realty, also known as real property, is first rights of use of objects and concepts above all other claims. Therefore, real property cannot exist without some valid divine right of use, also known as divinity. Therefore, no superior trust may exist unless it is connected and created from a valid true trust, which itself must be connected and created from a valid divine trust. Canon 1948. A superior trust may only be associated with one true trust and therefore one true person. A true person is always the owner of a superior trust. Canon 1949. A superior trust is formed when a true person gives, grants and conveys certain rights of use, known as realty or real property, to a superior trust, thus creating the trust corpus of the superior trust, also known as the superior body corporate, also known as the superior person, having legal personality. The higher society to which a superior person is a member is always the executors and administrators of any benefits, with the superior person as trustee. Canon 1950. A superior trust is formed upon a true person forming an agreement by valid deed to use certain property in accordance with these canons and the sacred covenant Pactum De Singularis Coelum. Certain divine rights of use, also known as divinity, are then conveyed into the superior trust for the purposes defined by the deed. Canon 1951. The superior person of a superior trust is always a living corporate body. A superior person dies when the true person that formed it also dies. Canon 1952. As a living, inter vivos, trust, a superior trust lawfully terminates upon the death of the person or juridic person listed as beneficiary. Canon 1953. Any person, aggregate, or entity that claims ownership of real property without demonstrating the existence of an associated true trust and divine trust in accordance with these canons defies both logic and reason, in addition to being a deliberate fraud and therefore null and void from the beginning. Article 88, Inferior Trust. Canon 1954. An inferior trust is the lowest form of living trust, possessing the lowest form of rights of ownership, formed by inferior law, claims, and statutes inconsistent with these canons and the sacred covenant. Pactum De Singularis Coelum. Canon 1955. Any trust that is inconsistent with these canons and the sacred covenant Pactum De Singularis Coelum is therefore by law an inferior trust, no matter how old, what claims are made, how many are prepared to enforce these claims or believe such claims to be true. Canon 1956. By definition, an inferior trust is inferior to a superior trust. Therefore an inferior trust can never hold real property, being first right of use above all others. Therefore any such claims of superior title, real property, by any inferior trust defies all norms of logic and reason and are automatically null and void from the beginning. Canon 1957. All estates formed under Roman law are by definition formed under testamentary trusts, whether or not such structure or status is acknowledged. Therefore all estates belong to inferior trusts. Canon 1958. In accordance with these canons and the sacred covenant Pactum De Singularis Coelum, all property of all inferior trusts is ultimately subject to the control and administration of one heaven. Any executor or their trustees of an inferior trust that denies this absolute fact is in gross breach of their duties and is immediately ineligible to remain in the capacity as a trustee or executor. Article 89, Supreme Trust. Canon 1959. A supreme trust is a valid aggregate divine trust registered into the Great Register and public Record of one heaven whereby 100 deceased members consent to convey their divine trusts holding actual divine form and rights into a new supreme divine trust. Canon 1960. A deceased member of one heaven is a divine person no longer having use of a living flesh vessel in the form of an organic higher order being such as a Homo sapien body. Divine persons owning a living flesh vessel are not permitted to convey their form and rights into a supreme trust. Canon 1961. As condition and consent in being a member of one heaven, all deceased members and the divine Creator grant the treasury of one heaven the right to form a necessary number of supreme trusts for the benefit of the society and all future generations of deceased and living members. Canon 1962. The total number of supreme trusts may not exceed the total number of deceased members as indicated by the issue of valid membership numbers divided by 100. Canon 1963. When forming a new supreme trust, the treasury of one heaven shall respect the historic relationships and connections between deceased members and major events in their histories so that members are grouped together in a supreme trust sharing similar history, events, and values. Therefore, for example, deceased leaders of a civilization or entity should by right be connected together, as should family members, as should those that died together. Canon 1964. In accordance with these canons and the sacred covenant Pactum de Singularis Caelum, upon the formation of a new supreme trust, the treasury of one heaven is permitted to issue 1 supreme bill of exchange, 1 supreme certificate of equity, 1 supreme bond of promise, and 1 supreme credit title, all to the base value of 1. Canon 1965. A supreme bill of exchange, also known as a supreme bill and simply bill, may be issued against the 100 units of debt conveyed from the divine trusts into the supreme trust. A supreme bill therefore represents the most perfected debt instrument above all other debt instruments, with the 100 members as individual acceptors through their existence of their membership numbers on any bill of exchange instrument. Canon 1966. When monetized, a supreme bill of exchange represents the most superior form of debt currency of any and all systems. The failure for any juridic person to refuse acceptance of a supreme bill of exchange shall represent a most serious fraud and automatically render such a person, entity, or aggregate in extreme dishonor of all laws of trade and exchange, subject to immediate sanction and penalty. Canon 1967. A supreme certificate of equity, also known as a supreme share certificate and simple share, may be issued against the 100 units of actual form of spirit and mind conveyed from the divine trusts into the supreme trust. A supreme certificate of equity therefore represents the most perfect and highest certificate of equity above all other forms and certificate of equity. Canon 1968. A supreme bond of promise to pay, also known as a supreme promissory note, also known as simply a bond, may be issued against the 100 units of energy and spiritual activity conveyed from the divine trusts to the supreme trust. A supreme bond of promise to pay therefore represents the highest form of promissory note and bond possible. Canon 1969. A supreme credit title, also known as a supreme credit, represents the full legal title held by the treasury of one heaven as trustees over the assets held in supreme trust. Because of the extreme value of a supreme credit, it is forbidden to sell or purchase a supreme credit. However, the treasury of one heaven is permitted to use the share and bond of a supreme credit as underwriting to a universal trust representing a universal gold credit, including the conveyance of the bill to the universal trust. Canon 1970. The holding of an authenticated abstract of a supreme credit does not imply in any way a transfer of ownership, nor title, nor rights, nor assets. Any person, juridic person, or entity that seeks to monetize, use a supreme credit except for the express purpose the abstract was provided is guilty of gross fraud and dishonor, with any subsequent transaction null and void from the beginning. Article 90, Universal Trust. Canon 1971. A universal trust is a valid aggregate true trust registered into the Great Register and Public Record of One Heaven or Global Okadayan Society. There are only two permitted types of universal trusts, a universal credit trust and the Hokadaya Universal Trust, also known as the Hokadaya Trust. Canon 1972. The Hokadaya Universal Trust is the complete and entire universe as one valid person representing the divine trust, unique collective awareness in the personality of Hokadaya as all of existence. As Hokadaya is registered into the Great Register and Public Record of One Heaven, Hokadaya is recognized as a full member of One Heaven. Canon 1973. No person, entity, aggregate, or force may claim a higher trust within the dimension of the universe than the Hokadaya Trust. Canon 1974. Only executors or trustees nominated by the Treasury of One Heaven are permitted to act as executors or trustees on behalf of the Hokadaya Trust. Canon 1975. Wherever valid business or trade of any kind is engaged by the name Hokadaya in association with these canons and the sacred covenant Pactum de Singularis Coelum, it shall be according to the rights and obligations of the Hokadaya Trust. Canon 1976. Any inferior juridic person or inferior trust or estate that seeks to enforce a claimed control over the assets of the Hokadaya Trust is in grave breach of all forms of law, and such act is immediately null and void. Canon 1977. As these canons have been promulgated and notice given, it is the responsibility of inferior juridic persons and their officers to make effective change to their records for any business or trade of any kind by the name Hokadaya. Failure to correct their records is no excuse. Canon 1978. Any man or woman acting as surety to an inferior person that seeks to enforce a claimed control over the assets and direction of the Hokadaya Trust or derivative thereof, automatically assumes and consents to the full liability and consequences of their actions, including the immediate loss of any legitimate right to act as trustee or executor, any subsequent charges of fraud, and all penalties and punishments. Canon 1979. Any man or woman who falsely purports to represent Hokadaya without valid authorization is guilty of serious fraud and automatically assumes and consents to the full liability and consequences of their actions, including the immediate loss of any legitimate right to act as executor or trustee, any subsequent charges of fraud, and all penalties and punishments. Canon 1980. A universal credit trust is formed by the lawful conveyance of 1/100 th of the value of a supreme bill of exchange into the new universal true trust, including divine rights of underwriting by supreme equity and supreme bond. Canon 1981. All universal credits trusts are administered by the Globe Union Treasury in accordance with these canons and the Charter of the Globe Union and Globe Union Reserve Bank. Article 91, Global Trust. Canon 1982. A global trust is a valid aggregate true trust or superior trust registered into the Great Register and Public Record of a Global Okadayan Society. There are three types of global trusts: global credit trusts, global true trusts, and global superior trusts. Canon 1983. A global credit trust, also known as a global silver credit trust, is formed by the Treasury of the Globe Union upon the conveyance of real property from a universal credit trust, also known as a universal gold credit, in accordance with the charters of the Globe Union and the Globe Union Reserve Bank. Canon 1984. A global true trust is formed for each global juridic person specifically named within the sacred covenant Pactum de Singularis Coelum and associated covenants and charters by its divine Personality and conveyance of divine right of use, also known as divinity. Canon 1985. A global superior trust is formed by the individual covenant or charter of the global juridic person, and global true trust for each of its organs and entities into which real property, or first right of use, of objects and concepts by divine right are conveyed. Article 92, Civil Trust. Canon 1986. A civil trust is a valid aggregate true trust or superior trust registered into the Great Register and public record of a global or civil Laodicean society. A civil trust is generally for a nation, or province, or community or town for the benefit of its members. An aggregate larger than a nation is usually a global trust. Canon 1987. Only one civil true trust may be formed for each civil juridic person named within the sacred pronouncements of Laodicea, the sacred covenant Pactum de Singularis Caelum and associated covenants and charters. Canon 1988. A civil superior trust is formed by the individual charter of the civil juridic person and civil true trust for each of its organs and entities into which real property, or first right of use of objects and concepts by divine right are conveyed. Article 93, Mercantile Trust. Canon 1989. A mercantile trust is a valid aggregate superior trust registered into the Great Register and public record of a global or civil Laodicean society. A mercantile trust is generally for a trade and commerce. A mercantile trust is always a superior trust and can never be a true trust. Canon 1990. A new mercantile trust is formed when one or more true persons holding various property agree to form a new trust with specific mercantile objectives by conveying and combining these rights under deed and title. Article 94, Union Trust. Canon 1991. A union trust is a valid aggregate superior trust registered into the Great Register and public record of a civil Laodicean society. A union trust recognizes the union between two consenting adults for the purpose of forming a singular superior person in the trade and transaction of their lives. A union trust is always a superior trust and can never be a true trust. Canon 1992. A new union trust is formed when two true persons holding property agree to form a new trust by conveying and combining these rights under deed and title. Canon 1993. The life of a union trust is the life of the union representing at least two members including children. Upon a request to terminate the trust by one or both of the founders and no children exist, the trust is terminated. However, in the event children exist, the union trust survives until the children reach majority, also known as adulthood. Article 95, Clan Trust. Canon 1994. A clan trust is a valid aggregate superior trust registered into the Great Register and public record of a civil Laodicean society. A clan trust is always a superior trust and can never be a true trust. Canon 1995. A new clan trust is formed when two or more true persons of the same clan and blood holding property agree to form a new trust by conveying and combining these rights under deed and title. Canon 1996. The life of a clan trust is the life of the clan representing at least two or more members. Upon the clan trust only representing one member, the clan trust is terminated. Article 96, Official Trust. Canon 1997. An official trust is a valid aggregate superior trust registered into the Great Register and public record of a global or civil Laodicean society. An official trust holds real property relating to an official position within a valid Laodicean society. An official trust is always a superior trust and can never be a true trust. Canon 1998. A new official trust is formed when a global or civil Laodicean society conveys property from a true trust representing the office and a true person conveys their property and obligations to form a new superior trust. Canon 1999. The life of an official trust is the life of a true person holding the office. Upon leaving office, the rights bestowed by the true office trust revert, including any additional property and effects. However, the release of obligations of a true person having left office is dependent upon their oath and vows. Canon 2000. The obligations and agreements acquired through office outlive the termination of the official trust. By reverting to the true office trust and then conveyed to the new superior official trust of the new official. Article 97, Location Trust. Canon 2001. A location trust is a valid aggregate superior trust registered into the Great Register and Public Record of a civil Locadian society. A location trust holds real property pertaining to land and associated immovables and movables. A location trust is always a superior trust and can never be a true trust. Canon 2002. As land is physical matter within space existing in accordance with natural law, it cannot be owned by a fiction such as an owner, or trust. Therefore, in order to enable lawful ownership of land, a valid fictional form derived from the objective existence of land is required. This fiction is called location. Canon 2003. A location is a valid survey of the land and the creation of its metes and bounds so that the description is consistent with an unbroken succession of surveys from the accurate survey of divine law down to the cadastral location survey. Canon 2004. Neither Torrens title nor incomplete and inferior claims of survey may be used as valid arguments for succession in defining a valid location. Canon 2005. A location trust is equivalent in name only to a land trust, also known as land title. Canon 2006. A location trust is not equivalent to estate-based land title and rights, particularly real estate. Real estate is the first right of use within the estate, whereas real property is first right of use by divine right, above all other claims. Canon 2007. All land title based upon an estate and therefore testamentary trust is by logic and reason inferior to any land title based upon real property. Canon 2008. As all land title based on real estate is inferior to land title based on real property, all associated claimed liens, easements, and conditions of title have no lawful or material effect. Canon 2009. A new location trust is formed when one or more true persons holding various contested or agreed rights such as ownership, occupation, possession, and location agree to form a new trust by conveying and combining these rights under deed and title. The perfection of these various rights then determines the status of the title of the location trust. Canon 2010. There are only 4 types of status of a title concerning a location trust: perfect, clear, contested, and provisional. Canon 2011. A perfect title for a location trust is when the true persons hold proof of right of ownership, occupies the land in a valid Locadian society, conveys right of location into the new trust. Perfecting title. Canon 2012. A clear title for a location trust is when the true persons hold proof of right of ownership, but do not occupy the land in a valid Locadian society, conveys right of location into the new trust clearing the title. Canon 2013. A contested title for a location trust is when the true persons occupy the land, but their proof or right of ownership is contested by another true person, therefore suspending the conveyance of the rights of location into the new trust until the controversy is resolved. Canon 2014. A provisional title for a location trust is when the true persons occupy the land, they have made improvements to the land, they claim their right of ownership through possession and abandonment, or non-use by the owner, they have defined a location survey but neither the survey has been validated against all valid land titles nor has the owner not had time to lodge an objection. Thus they Conveyance of the rights of location into the new trust is suspended until a period of time for the owner to object. Canon 2015. In matters of dispute, a perfect title is always superior to a clear title, and a clear title is always superior to a contested title or provisional title. Canon 2016. The assertion and enforcement of a claim by an inferior juridic person through inferior estate title against a superior person and real property ownership constitutes a gross injury and fraud against the law, with no lawful form other than the rule of force. Canon 2017. Any inferior juridic person or inferior person that participates in gross fraud against the law by asserting inferior rights over lawfully superior rights accepts and consents personally to the full liability of their actions, including the pursuit of maximum punishment and penalty against them at the earliest opportunity. Article 98, Temporary Trust. Canon 2018. A temporary trust is a valid trust formed for the express purpose of temporarily administering assets and property in transition from one type of permanent living trust to another, including use in negotiable instruments. Canon 2019. In accordance with these canons and the Sacred Covenant Pactum de Singularis Coelum, all forms of temporary testamentary trusts, cestuique, vi, trusts, estates and other forms of trusts for the purpose of administering the assets of a deceased estate are henceforth forbidden by all forms of valid law. Canon 2020. Instead, all valid deeds and wills of testament form a valid temporary trust not exceeding 120 days in life before the trust must be terminated and all assets and property conveyed to another form of valid permanent trust. A temporary trust may not convey any property or assets to another temporary trust for the same heirs and beneficiaries. Canon 2021. A temporary trust as part of a negotiable instrument is permitted to exist beyond 120 days when such instrument conforms to the standards of negotiable instruments of these canons. Article 99, Estate. Canon 2022. An estate is a fictional form being a valid record in a type of register known as a roll, issued by some authorized ecclesiastical body, sovereign body, or body politic, denoting the assumed or actual beneficial rights or privileges and obligations of one or more persons of the same condition and circumstance. A valid record in an estate roll creates a unique legal entity having certain limits of legal capacity or standing or status within the jurisdiction of the body and control of the body that created it. Therefore, in the first instance, an estate is equivalent to the concept of a unique legal person, and 2. The limits of legal capacity or standing or status determined by the valid record in the estate roll owned by the authorized ecclesiastical body, sovereign body, or body politic that created it therefore defines to what extent other property may, or may not, be held and used as privileges and liberties by the beneficiary claiming use of the legal person. Therefore, in the second instance, an estate is equivalent to the primary legal title and legal capacity and legal standing of a particular class of persons, and 3. Subject to such limits of legal capacity and legal standing, an estate may then hold one or more beneficial rights of use or property as privileges and liberties within one or more temporary beneficial trusts associated with the estate, i.e. real estate and personal estate. Therefore, in the third instance, an estate is equivalent to the aggregate property of immovable, movable, corporeal, and incorporeal things associated with these temporary trusts, i.e. the whole of the estate, and 4. To properly administer the affairs of the estate, the beneficial rights, also known as property, may then be pledged, promised, assigned, granted, or delegated as security to form one or more assets. The value of such assets may then be monetized or securitized through various funds, agreements, licenses, accounts and certificates. Therefore, in the fourth instance, an estate is equivalent to the aggregate monetary value of the net assets of the estate after all debts have been discharged. Canon 2023. The term estate was first created under the 8th century sacred law, of the Catholic Church by the Carolingians and then revived in the 16th century, comes from the 8th century Anglaise word estate meaning state possessing rights of some level of self-government, and the government, or condition of such rights, itself derived from the Latin terms meaning by reason of, out of and statuo meaning to decree, prescribe, or judge, status. Hence, the term estate literally means by its etymology by reason of, royal, decree, prescription, or judgment. Canon 2024. All valid estates exist under certain fundamental assumptions. I. The rules of formation and management of an estate roll and lesser registers must exist as public law within the rules of the ecclesiastical body, sovereign body, or body politic that created it, and 2. The rights associated with an estate are always rights of use, also known as property, and not the primary rights of ownership. Thus, estates always concern property as rights of use, and 3. As the rights associated with an estate are always right of use of some right, a separate trust must first exist before the estate is created, and furthermore, that the rights being the source of the rights of use in question must also have been named and conveyed into the existing trust by a trustor, and 4. The authorized ecclesiastical body, sovereign body, or body politic that created the estate roll owns legal title to any such rights conveyed into such an estate, and v. All rights in estate, within the estate, are beneficial title or equitable title and not legal title. And 6. Beneficial title means one or more privileges or liberties that, subject to the rules of the estate, may be withdrawn or forfeited or alienable, and 7. Equitable title means a privilege not in possession of the beneficiary, but claimable and recoverable through a qualified form of law with equity powers, being rights of a surrogate chancery court. Thus, certain permits, titles, letters, certificates and patents issued to a beneficiary as equitable title does not necessarily mean the beneficiary holds one or more privileges other than to sue in a valid court of equity to claim or recover one or more of these such rights, and 8. The rules for the administration of property, rights of use, within the estate is through a deed of testamentary disposition, otherwise known as a will by a testator, or in its absence, intestate, some other established and authorized rules, and 9. For every valid estate, a fiduciary must be named and duly appointed to govern the affairs of the estate, either as an executor, or appointed administrator in the absence of clear instruction or dispute of authority, and x. For every valid estate that engages in trade or commerce, at least one duly appointed agent must exist and be duly appointed, registered, and acknowledged to manage the day-to-day business of the estate under the authority of the executor or appointed administrator as the principal. Canon 2025. As a valid estate is created via a valid entry and formation of a record into some form of estate roll, the general authority, nature, and function of rolls apply. I. The authority to form a roll is defined by the limits of authority of the constituting instrument of the relevant trust or estate or fund, and 2. The rights, powers, and property prescribed to those persons as estate created and defined within a roll cannot exceed the rights, powers, and property of the trust or estate or fund itself. And 3. All rolls are completely and exclusively ecclesiastical property and can never belong to a trust, or estate, or fund that formed or inherited it. Instead, all rolls are the property of one heaven. Therefore, all estates are the property of one heaven, and 4. All roles are hierarchical in their inheritance of authority and validity from one heaven, beginning with the highest being the great role of divine persons. Therefore, the highest estates are divine estates and the lowest are inferior estates. A role that cannot demonstrate the provenance of its authority has none and is null and void from the beginning, and v. As all roles are completely and exclusively ecclesiastical, absolutely no clerical or administrative act may take place in association with a role unless by a duly authorized trustee, under active and valid sacred oath and vow in a manner consistent and in accord with these canons, and 6. The entry of a record into a roll is completely invalid unless the memorial or deed of the act giving authority is done without duress, is done freely and with full knowledge and is consistent and in accord with these canons and the most sacred covenant Pactum De Singularus Caelum. Canon 2026. Valid estates as valid records on a roll may be further defined in hierarchy of authority, form and function as divine, true, superior, juridic or inferior. A divine estate is a valid purely spiritual estate representing the collection of rights and obligations of a divine person recorded as a valid entry within a divine roll constituted in accord with the most sacred covenant known as Pactum De Singularus Caelum. No roll or person is higher, and 2. A true estate is a valid estate representing the collection of rights and obligations of a true person, office of man or office of woman, recorded as a valid entry within a physical and temporal roll constituted in accord with the society of one heaven in the recognition of the most sacred great roll of divine persons and the great register and public record of one heaven, and 3. A superior estate is a valid estate representing the collection of rights and obligations of a superior person recorded as a valid entry within a physical and temporal roll constituted in accord with a valid Hokkaidan society, and 4. A juridic estate is a valid estate representing the collection of rights and obligations of a juridic person recorded as a valid entry within a physical and temporal roll constituted in accord with a valid Hokkaidan society, and v. An inferior estate is any estate representing the collection of rights and obligations of a person as an entry within a physical and temporal roll formed under law not in perfect accord with these canons. All Western, Eastern, and Roman estates are inferior estates. Canon 2027. Whilst many of the statutes, procedures, and rules regarding inferior Western Roman rolls and inferior Western Roman estates are contradictory, false, misleading and deliberately deceptive, the fundamental architecture of estates within the Western Roman system acknowledges the hierarchy of authority, form, and function. The ecclesiastical estate is and remains the highest form of inferior estate within the Western Roman system, with spiritual persons being the highest form of person within the same system, and 2. The real estates, as originally in the context of real still meaning royal until the late 17th century being defined by patent rolls, charter rolls, ancestral rolls as being granted higher status of persons. By the late 18th century, real estate was depreciated to rights of possession and chose in chancery, with nobles rising to pseudo-ecclesiastical estates by claiming themselves as parochial bodies, and 3. Personal estates as rolls and estates formed under statutes of the commons and lesser parliaments, and 4. The fourth estates as rolls of media, publishers, military, mercenaries and privateers. Granted letters of marque to perform acts of brutality, enforcement, terrorism otherwise illegal. And v. Deceased estates introduced by the end of the 19th century in the form of residential rolls of residence or remainder estates of the legally dead, wherein the modern poor are deprived even of being considered legal persons in certain circumstances and therefore without any legal capacity under Western Roman laws.